SEC director admitted defeat and apologized to Ripple XRP. U.S. Representative Brad Sherman recently advised the Securities and Exchange Commission, SEC, to go after crypto exchanges that supported Ripple's XRP token. However, in a recent interaction with Fox Business journalist Eleanor Tourette, Sherman made another claim against the token. Welcome to the Finance Up channel. If you liked this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end, to like and subscribe. David Schwartz, Chief Technology Officer of the blockchain company Ripple, believes that Massachusetts Senator Elizabeth Warren may be right when it comes to regulating cryptocurrencies. It's not an awful position to work with. At least it agrees that regulations need to change and that it is important to get crypto regulation right. In a recent article published by the Wall Street Journal, Warren argues that cryptocurrency could eventually destroy the economy if there is not proper oversight. Although the senator acknowledges that cryptocurrencies can potentially make the financial system more inclusive, she also points to the fact that history is littered with all sorts of fraudulent financial schemes that were advertised by criminals and charlatans. Warren argues that the heads of crypto projects that violate the law are no different from other financial instruments, so the Ministry of Justice should use all its strength. Warren also dealt a blow to companies engaged in the mining of cryptocurrencies, which load the energy system and increase greenhouse gas emissions. She stressed that the cryptocurrency should be subject to the same rules as other financial sectors. On Twitter, Schwartz wrote that this is not a terrible position to work in. It's not a terrible position to work in. At the very least, she agrees that the rules need to change and that it is important to ensure proper regulation of cryptocurrencies. Warren has long been one of the leading crypto skeptics of Congress. In a September interview, the progressive MP called the cryptocurrency unreliable, destructive, and dangerous. In early April, Warren compared buying Bitcoin to buying air. Garlinghouse repeats that Ripple is ready to negotiate with the SEC if the agency provides clarity on XRP, which will help American institutions such as Bank of America gain a competitive advantage through the use of Ripple ODL. Ripple Labs CEO Brad Garlinghouse reiterated that the lawsuit with the Securities and Exchange Commission, SEC, can only be settled if the federal agency provides regulatory clarity regarding XRP. Garlinghouse announced this to Link2 sales director Nick Burifato at the recently concluded Ripple Swell 2022 conference in London. I met Brad Garlinghouse face to face and he made it clear that Ripple is ready to negotiate with the SEC if they can clarify the situation with XRP, Burifato said. According to him, Garlinghouse also said that American financial institutions are monitoring the development of the ongoing lawsuit between the SEC and Ripple. He added that these companies will join Ripple when the blockchain company comes to an agreement with the SEC. Burifato said Garlinghouse was specific about Bank of America. The head of Ripple believes that Bank of America will gain a competitive advantage when the blockchain company settles with the Securities and Exchange Commission. Bank of America will gain a competitive advantage when the SEC case against Ripple is settled by using ODL in the market. Ripple Labs CEO Brad Garlinghouse told Link2 sales director Nick Burifato at Ripple Swell 2022 in London that Bank of America will gain a competitive advantage when the SEC case against Ripple is settled, through the use of ODL in the market. In November 2020, Ripple named Bank of America as a leading participant in its global Ripple Net payment network. Despite Ripple's lawsuit against the SEC, Bank of America is still listed among the financial institutions of the network. Currently, it does not appear that the Securities and Exchange Commission has agreed that XRP is not a security. On the contrary, the SEC seeks to prove that XRP is a security using the Howey test, as well as considering XRP sales on the secondary market, such as exchanges, as sales of securities. It is worth noting that Ripple failed to reach an agreement with the SEC before the company was sued. The parties filed petitions, objections and responses for summary proceedings. Earlier this month, the SEC won a similar lawsuit against the Library crypto company, which gave the agency confidence that it would also win Ripple's lawsuit. Supporters of XRP believe that Ripple has more chances to prove that the cryptocurrency is not a security. According to today's tweet by attorney James Phelan, Coinbase has officially submitted its amicus opinion in support of Ripple's fair notice defense. Coinbase has formally filed its amicus brief in support of Ripple's fair notice defense. The leading cryptocurrency exchange officially requested permission to file an amicus opinion in support of Ripple 2 weeks ago. The firm's request, along with 11 others, was approved on Monday by Judge Annalisa Torres, according to a document published by Fox Business reporter Eleanor Terrett a few hours ago. Accordingly, requests for amicus curiae resumes are being met, the document says, referring to various requests. Judge Torres gave all interested parties until November 18 to submit their statements. Coinbase, citing its interest in the case in its request, noted its unique point of view as an exchange that had no choice but to exclude the XRP token from the listing in light of what it called the SEC's unexpected coercion to harm its customers. In his official report, he also notes that the uncertainty associated with the lack of clarity in regulation in the United States and the fear of sudden enforcement put the American stock exchange at a disadvantage compared to international competitors. The cryptocurrency exchange stressed that the securities law of the 1930s, in violation of which the SEC accuses Ripple, was not intended for cryptocurrencies. In the litigation between Ripple Labs and the U.S. Securities and Exchange Commission, SEC, both sides took an important step towards the decision of Judge Annalisa Torres. According to a tweet by defense attorney and former federal prosecutor James K. Phelan, both Ripple and the SEC filed summary judgment briefs yesterday morning. Initially, the two parties to the dispute had to submit their aforementioned papers by November 30. On December 2, Ripple and the SEC were supposed to meet to jointly discuss the amendments. Finally, on December 22, collective petitions were to be filed to seal all documents related to petitions for a simplified trial. However, as Phelan tweeted, the schedule is likely to shift. This assumes that the edited responses will be submitted around this Friday, December 2, Phelan said. The lawyer explained that this assumption is based on the facts that the edited petitions for simplified judicial proceedings should have been submitted on September 19, but filed on September 17, and the edited objections should have been submitted on October 24, but filed on October 21. In recent days, there have been suggestions that December 5, and now, possibly, December 2, could be a significant date for the likelihood of settlement of disputes between Ripple and the SEC. The focus is on Hinman's documents, which can be a strong trump card for Ripple. In order to keep these documents secret and prevent a broader impact on the overall regulation of the cryptocurrency market, the SEC may agree to a settlement. In this regard, what is edited or not edited can be crucial in summaries. If Hinman's documents are not made public by Ripple as evidence, it will be a convincing sign that the company has an advantage. However, a member of the XRP community, lawyer Fred Rispoli, does not believe that it will end so soon. According to him, it is unlikely that the SEC will agree to release Hinman's emails without a court order. And this decision will come into force only after retaliatory measures are taken on January 9, Rispoli said. He doesn't expect it to happen before the end of January. The current price of XRP for today you can see yourself on the screens, and the trading volume for 24 hours is $1,294,436,065 US. We are updating our XRP price in US dollars in real time. XRP has dropped 4.08% in the last 24 hours. Do you think XRP will be able to win the court and restore its former price? Write the answers in the comments. That's it for today. Thank you for watching this video to the end. If you liked it, then don't forget to like it and subscribe to the channel.